you, Mr Speaker. It's an honour and a privilege to open the debates for the third reading of the Terminally Ill Adults End-of-Life Bill. It has been a long journey to get here, and I do not underestimate the significance of this day. It is not often we are asked to wrestle with issues of morality, ethics and humanity. But with great privilege of this job comes great responsibility, and never more so than at a time like this. Benjamin Franklin told us that in this world, nothing can be said to be certain except death and taxes. In this House, we debate the latter incessantly. But here, and in the country as a whole, discussing death is something we tend to shy away from. And yet, it will come to us all and to all those we love. And Mr Speaker, we all have our own experiences of death, loss and grief. There are good deaths and there are bad deaths. And I, like many, have experienced both. Mr Speaker, I appreciate that for some colleagues the journey to this point has been a difficult one, and I want to pay tribute to the way in which the overwhelming majority of members have approached this subject. Yeah. The second reading back in November was quite rightly seen as an example of Parliament at its best. Contributions from across the chamber were incredibly powerful. The atmosphere was respectful and people listened with care. I hope we will see the same today, Mr Speaker. Yeah. And I want to thank you, Mr Speaker, and your team, along with the fantastic clerks and procedural experts who have ensured parliamentary protocols have been followed and have guided us through the intricacies of what can be a complex parliamentary process, which is steeped in tradition but not always easy to follow. And of course, process is important, but it's also important to remember we are not voting on the merits of parliamentary procedure. We are voting on an issue that matters deeply to our constituents. Yeah. Indeed, the issue before us today is very personal for many people, so many of our constituents, but many of us as well. It is an issue which transcends party politics, and I want to thank colleagues from across the House who have shared their very personal stories with me. And I'm grateful to all colleagues who have studied the detail of the bill. It is, of course, essential that we come to a decision based on the content of what it actually says. And I've been pleased to work with members on all sides of the debate to ensure that this legislation is something that Parliament can be proud of. A cogent, workable bill that has one simple thread running through it: the need to correct the profound injustices of the status quo and to offer a compassionate and safe choice to terminally ill people who want to make it. I won't go into the amendments in detail, as I know that is not the purpose of this debate. But whether it's adding further safeguards and protections for patients through additional training around coercive control, or the addition of specialist expertise through the inclusion of multidisciplinary panels, widening the provision for professionals to opt out of the assisted dying process, providing additional employment protections, or prohibiting the advertising of assisted dying. Cross-party working has strengthened the bill. And the many safeguards... I will give way.
Well, I'm grateful to the Honourable Lady for giving way. What level of concern does it give her that since second reading and today, a growing canon of professionals and their independent professional bodies have urged great caution about this bill, not on the principle, but are opposed to the details of this bill and believe it should be defeated?
I thank him for his intervention. Thank you, Mr Speaker. I think what he's saying is people have got different views, and they do have different views. We have different views in this House, and different people in different professions have different views. Every Royal College has a neutral position on assisted dying because of that. I've been pleased to work with members on all sides of the debate to ensure that this legislation is something that Parliament can be proud of. And the many safeguards in this bill ensure only terminally ill patients that are eligible under the strict criteria and who want to access assisted dying can do so.
I felt disturbed by quite a lot of the emails that I received from constituents, some of them who are my friends and who I like, implying that we here are either too stupid or careless to care for the most vulnerable. And is it not true that we all do, whatever the decisions we make today, and we have to continue to educate people and tell people what this bill is about?
I thank her for that intervention, and she's absolutely right. The detail does matter, and that's why I'm so grateful for colleagues who have engaged in the detail. We know that there are different views within the public, and we have to take on board the concerns of vulnerable groups, and that's why the safeguards are so important. But I would also say that there is no one more vulnerable than someone who is dying. I'm just going to make some progress. So patients must have an inevitably progressive illness or disease which cannot be reversed by treatment. And a person is not considered to be terminally ill only because they have a disability or a mental disorder. These clear, strict criteria, plus the multiple capacity assessments, exclude possible serious mental health disorders such as anorexia. I was also very pleased to support the change advocated for by Marie Curie and Hospice UK, which ensures an assessment of palliative and end-of-life care as part of the first report on the Act. We know from other countries, in no small part due to the 14-month inquiry by the Health and Social Care Select Committee, that palliative care and assisted dying can and do work side by side to give terminally ill patients the care and choice they deserve in their final days. It should not be an either-or for dying people. And we need to channel our energies into supporting all options for terminally ill people. I will give way.
I'm very grateful to the Honourable Lady for giving way. As she knows, the leading experts in palliative care have come out to oppose the bill, and they point to the fact that hospices are underfunded and that they do not have the same ability to serve patients. So I do gently question whether we are in a position today to make a judgment that patients truly would have a choice at end of life.
I thank him for his intervention, but I would say, as I've said previously, people working in palliative care have a mixed range of views on this subject. Some, and I've met with palliative care doctors, some are very, very supportive of a change in the law because of the suffering they have seen. I'm just going to make some progress, if I may. But, Mr Speaker, it is an either-or decision for us today. Either we vote for the safe, effective, workable reform contained in this bill, or we say the status quo is acceptable. Over recent months, I've heard hundreds of stories from people who have lost loved ones in deeply difficult and traumatic circumstances, along with many terminally ill people themselves. I spent some time with some of these families yesterday. They are real people with real stories, and they deserve to be heard. Adil's terminally ill father took his own life by buying drugs on the dark web. It was his third attempt, and Adil found him in a truly desperate state. He and his sister will never get over that night, or the police investigation which followed. Katie waved her mum off as she made the lonely and costly journey to Switzerland, where she had a peaceful and dignified death. But the family had no chance to say a proper goodbye, and her dad made the journey home grieving and alone. Others have had to watch their loved ones die harrowing deaths despite receiving excellent end-of-life care. Warwick's wife Anne had the maximum dose of sedative, but it wasn't enough to stop the choking and suffocation due to peritoneal cancer, and she begged him to help her put an end to her suffering. But he didn't want the last memory she had of him to be stood over her with a pillow. And there are many, many more. And perhaps, Mr Speaker, most importantly, I have spoken to terminally ill people themselves. We've spent a lot of time talking about them, but not always with them. Pamela and Sophie both have terminal breast cancer and shared their stories yesterday. Pamela is a proud Christian who just wants to have choice when her time comes. And Sophie, who is allergic to opioids, wants to ensure her beautiful daughter has nothing but happy memories of their time together. Not supporting the bill today is not a neutral act. It is a vote for the status quo. And it fills me with despair, just one moment, and it fills me with despair to think MPs could be here in another 10 years' time hearing the same stories. And Mr Speaker, I will.
That's really kind of you. I thank my honourable friend for giving way. I have to say I thought very, very carefully as someone that came into this House supporting this principle before voting against this bill at second reading. Can I just ask the honourable member to explain, there are differing views, but before MPs put their name, not to this principle, but to this specific bill, why are the vast majority of palliative care doctors, geriatricians and groups representing people with disabilities, eating disorders and domestic violence all in opposition, not to this principle, but to this bill? And that includes people who support the principle of assisted dying, but not the specific bill. Can the honourable member explain their opposition?
I think we've kind of covered that point already, but these are not homogenous groups of people. They have different views and different opinions. And Mr Speaker, if we look at the inconsistencies of the current law, it also just doesn't make sense. If someone with a terminal illness voluntarily stops eating and drinking, it is legal for them to starve themselves to death. A competent patient has the right to refuse foods and fluids even if they will die. The exercise of this right is sometimes proposed as an alternative to assisted dying. I suppose you could argue that starving yourself to death is one way of taking control at the end of your life. But it is a deeply traumatic experience for the person and their loved ones, and there are people here today who have direct experience of that. So we have a system, I'm going to make some progress. So we have a system where it is legal to starve yourself to death, which can take days or weeks, but it is not legal to seek assistance from a doctor to take an approved substance yourself to end your pain or suffering and take back control in your dying days. Mr. Speaker, it is also legal in this country to discharge yourself from medical care or refuse life-sustaining treatment, such as ventilation, CPR or antibiotics, as long as you have mental capacity to do so and make the decision of your own accord without any harassment from anyone else. You might think this is fine, and I agree. But there is no requirement for 2 doctors, a psychiatrist and a social worker, no lawyer and no judge. This is legal. And yet what is being proposed in this bill with so many more safeguards and protections is not. It simply does not make sense. I'm not going to take any more interventions because lots of people want to speak. And of course, there are the criminal offences which the bill introduces, none of which exist now, including life imprisonment for anyone who induces another person to take the approved substance, and 14 years in prison for coercion, dishonesty or pressure. Mr. Speaker, this is a robust process which goes further than any other piece of legislation in the world, and it is far safer and significantly more compassionate than what we have now. And if we look internationally, there are clear, well-established, safe, compassionate assisting dying laws in existence. On Tuesday, I joined doctors from Australia who used 3 key words repeatedly: choice, control and relief. Dr Greg Mewett has got 20 years' experience as a GP, 22 years as a palliative care physician, and he spoke about the thorough approach that is taken to ensure safety and efficacy of the assisted dying process. Perhaps the most standout quote from that session came from Dr Jackie Davis, Chair of Healthcare Professionals for Assisted Dying. She said, "By introducing assisted dying, no more people will die, but far fewer people will suffer." Because, Mr. Speaker, this is not a choice between living and dying. It is a choice for terminally ill people about how they die. And I fully appreciate that some colleagues would never vote for any version of this bill, and I'm respectful of that, despite disagreeing. But to those colleagues who are supportive of a change in the law, but are hesitant about if now is the time, if we don't vote for change in the law today, what does that mean? It means we have many more years of heartbreaking stories from terminally ill people and their families, of pain and trauma, I'm going to finish if that's okay, of suicide attempts, PTSD, lonely trips to Switzerland, police investigations and everything else we've all heard of in these recent months. As the Commission on Assisted Dying said in 2011, 14 years ago, Mr. Speaker, the current legal status of assisted dying in the UK is inadequate and incoherent. It outsources a healthcare issue abroad, especially to Dignitas, instead of the government and Parliament assuming responsibility. That was 14 years ago, and we are in exactly the same position today. Things have got to change. And as the government's impact assessment states, the bill will improve equity of choice, ensuring that terminally ill adults from all socio-economic backgrounds can access end-of-life options within a regulated and safe framework. So as I draw my comments to a close, Mr. Speaker, there are essentially 2 ways we can look at the situation we're in. We can look through a legal lens. As legislators, we have a duty to change the law where it is failing. And when the last 4 directors of public prosecutions tell us that the law needs to change, surely we have a duty to listen. We need scrutiny before people die, not after. But most importantly, there is the human lens, which is how I approach most things. Giving dying people choice about how they die is about compassion, control, dignity and bodily autonomy. Surely we should all have the right, I'm going to finish shortly, surely we should all have the right to decide what happens to our bodies and decide when enough is enough. And of course, giving people the right to choose does not take away the right not to choose. So today we can vote with either our hearts or with our heads, Mr. Speaker. But either way, we should end up in the same lobby. Because on a compassionate human level, and as responsible lawmakers, we should support this desperately needed reform that is rigorous, practical and safe, and is rooted in the principles that should underpin any legislation: compassion, justice and human dignity. Thank you, Mr. Speaker.
The question is that the bill now be read a 3rd time. Sir James Cleverly.
Thank you, Mr. Speaker. I have no doubt the vast majority, probably every single member and right honourable member in this House, is sympathetic with the underlying motivation of this bill, which is to ease suffering in others and to try and avoid suffering where possible. And for the most part, this debate, both in this chamber and in committee, has been good-natured and conducted in a way that I think we can be proud. There has been, of course, more widely, questions about the motivations, both of those who are proponents of the bill and of those who oppose the bill. And whilst this is not about any individual one of us, I think it's only fair, because some questions are asked, I want to put a few things on the record about my own position on this. I do not come at this from a religious point of view. I'm an atheist, I'm a humanist. So this is driven by my concerns about the practicalities of this bill rather than any religious viewpoint. And it has been suggested, particularly when people talk about the experience they have had talking to people who have lost loved ones or who are themselves terminally ill, that if you had seen, I've had this said to me on a number of occasions, if you had seen someone suffering, you would agree with this bill. Well, Mr. Speaker, I have seen someone suffering. My closest friend earlier this year died painfully of esophageal cancer, and I was with him in the final weeks of his life. So I come at this not from a position of faith, nor from a position of ignorance, and I would hope the House would take those factors into consideration when I say what I'm about to say.
Jim
Thank you for giving way. And on the TV last night, they did a survey of doctors, GPs, and the relationship between the GP and the patient is incredibly close. Your children come into the world, your grandchildren come into the world, your GP's involved. But whenever the GP has to deliver a diagnosis of terminal illness to the patient, it's not just the fear in the eyes of the patient, it's the fear in the eyes of the GP and the doctor, the friend we all have. And does he, right on, remember, does he recognise the importance of this debate today and this vote, because it will change forever that relationship of trust between the GP and the patient in a negative way that will never change ever again?
James Leadbeater.
I mean, I will make reference to the broad point that he makes later on in my speech, and I would say I'm going to try not to take too many interventions, because many people have not had the chance to speak in this debate, and I want to give them the chance to do so. At the second reading debate, I made the point that we need to think about the detail of this bill and not just vote in accordance with the broad principles. I made the point that because it was a private member's bill, the opportunity to fundamentally change the bill is limited. So we have an enhanced duty to get it right first time. We were told at second reading that a lot of the concerns, a lot of the worries, a lot of the detailed questions would be resolved through the committee process. We were promised the gold standard, a judicially underpinned set of protections and safeguards. Those protections did not make it through committee. And I've also heard where people are saying, well, there are still problems, there are still issues, there are still concerns I have. Well, the Lords will have their work to do. But I don't think it is right, and none of us should think that it is right, to subcontract our job to the other place. We are making an incredibly important, a fundamental change, as the Honourable Member for Strangford highlights, a fundamental change in the relationship between medical professionals and those they serve. And if we make that change, we will introduce perhaps only a small but a permanent question mark in the minds of every patient, particularly a patient that is discussing a serious injury, a serious illness, or perhaps a terminal diagnosis. What is this medical professional expecting of me? What are they thinking? Where are they? Where is their head? Rather than the situation we have at the moment where that patient knows that that medical professional is duty-bound to do no harm, to preserve life, dignity, wherever possible. And that subtle change, Will you forgive me? No, go on.
Dame Siobhan McNaught.
On Tuesday, it is the 2nd anniversary of my sister's death. 3 weeks prior to her death, we took her to hospital because she had a blood infection. And in spite of agreeing to allow her into intensive care to sort out that blood infection, the consultant decided that she shouldn't go because she had a brain tumour and she was going to die. She was going to die, but not at that moment. I'm sure Mr. Speaker can understand that a very big row ensued. I won that row. She was made well, she came home, and she died peacefully. What does the honourable gentleman think would happen in identical circumstances if this bill existed?
James Cleverly.
She asked me to speculate into a set of circumstances which are personal and painful, and I suspect she and I both know that the outcome could have been very, very different, and the moments that she had with her sister, just like the moments I had with my dear friend, those moments might have been lost. So as I say, we have got to recognise that this is an important moment, and whilst I respect the Honourable Lady, I disagree with her assessment that it is now or never, and it is this bill or no bill.
Yeah.
And that a vote against this at third reading is a vote to maintain the status quo. None of those things are true. No. There will be plenty of opportunities, and indeed we are duty-bound, I think, stimulated by this debate, which is why I don't criticise her for bringing it forward, stimulated by this debate, to have a serious conversation about palliative care, a serious conversation about how we get to that. And I know that many people will say, oh, these are not conflicting or contradictory positions. But we also know, and I'll come upon this in the speech, and I'm going to crack on because otherwise I'll get told off by Mr. Speaker. We know that there will be circumstances where assisted dying will be on a statutory basis and provision of palliative care will not.
Yeah.
And so, and we also have to address the point that, look, we can all pray in aid of individuals and institutions to reinforce our positions on this. But as I say, we can't subcontract our decisions. And yes, we can fish around for people to come up with the perfect quote that reinforces our arguments, but another 5 minutes on Wikipedia or on Google or with friends of ours in the medical profession will find another voice that opposes that. So yes, it is a mixed picture in the medical professions, but I am struck by virtue, I'm struck by the number of professional bodies which are neutral on the topic of assisted dying in general, but are opposed to the provisions within this bill in particular. And we can't just say, oh, well, they are neutral on assisted dying, so therefore this particular vehicle has to progress. Because we carry a responsibility. It's what we are sent here to do, and we need to take it very seriously. And we must be rigorous on the specific details in this bill. And just like the Honourable Lady, I don't have time to go through every single argument that was had through committee, second reading and beyond. But to ensure that we are rigorous, I think there are three fundamental questions that we should ask ourselves, not lean on our friends and colleagues, but ask ourselves and ensure we answer fully and honestly. Firstly, and then
I thank the right honourable gentleman for giving way on that point, and he'll remember in 2021 he and I worked cross-party in terms of identifying the inequalities within certain communities and getting them to come forward with the issue around the COVID vaccination. Does he agree with me that one question we as parliamentarians need to ask ourselves, how is it right that some communities are not denied basic healthcare within the current system? How is it right that some communities don't have access to good palliative care? How is it right that some communities still have a mistrust of the medical profession? And how is it right that we are not listening to their voices?
James Cleverly.
The Honourable Lady makes an incredibly important point. I will touch upon that briefly in the points. I'm not minded to take more interventions because otherwise I will steal time from others. So 3 questions we need to ask. Firstly, are we happy, not for this principle, but for this bill as drafted to become law? And there are many elements that I've already discussed are concerning. Within the criteria set out, medical professionals do not need to seek deeper motivation. We've said there is not a real choice between palliative care and assisted dying because one will have a statutory underpinning, the other will not. That, as I say, gold standard of protections were lost during the committee process because a number of professional bodies, and I will need to make space, a number of professional bodies have said they do not have the capacity, they do not have enough people to fill the slots that this bill demands of them. Secondly, in terms of fundamental changes, are members and right honourable members genuinely happy to write the blank cheque that this bill demands? Because it is normal for the Secretary of State of a government department to decide when a piece of legislation comes in force. And they make that decision based on the state's ability to deliver that legislation. Yeah. Commencement dates matter. Yeah. They are not just some arbitrary date on a piece of paper. And I understand the desire of people to make sure that this can't be kind of lost in the down the back of the sofa when it comes to government work. But when people upon whom we rely to deliver this say they are not ready and they don't feel they will be ready, they don't have enough people, they don't have enough capacity, they will have to take resource from current provisions to move across to this provision, which will be driven by a statutory requirement and a locked-in commencement date, we should listen. We should listen. And if the people who are going to make this work and work as well as we hope it will if it becomes legislation, say that they are not confident that they can make it happen, we should be very, very careful about demanding that they prioritise this. And that's what this legislation says. They prioritise this above any other work that they might otherwise do. And thirdly, and the Honourable Lady hinted at this, and I mentioned this in an intervention at earlier stages in this bill, when it comes to things like coercion, or when it comes to actually the pressure that individuals put on themselves, when it comes to medical professionals raising this issue, we know there are inequalities in health provision already, none of which I think will be addressed by this bill. But the point I've also made is we know there are certain communities and certain people within those communities, particularly women, who are overly deferential both to men and men in authority. And if we can genuinely say that we have no fear whatsoever that a potentially vulnerable woman will sit in front of a medical professional who raises assisted dying, and even without implying it is the right thing for her to do, the very fact that they bring it up will have a significant influence on that woman's thinking. So we cannot believe, as it stands at the moment, that this will have a completely neutral effect across all communities. This will be the last intervention.
I thank the right honourable gentleman for giving way. We've put safeguards into the bill that mean there is a panel that looks at those issues and will ask questions like, has your doctor persuaded you to do this? Do we honestly think that someone who is a social worker or who is a psychiatrist or who is a lawyer is totally incapable of finding coercion? That is exactly what that panel is there to do, and that is exactly what those safeguards will provide.
Sir James.
The Honourable Lady makes an important point, but I refer her to the question 2 that I put. Those bodies say they don't have the people to populate those panels. And yet they are demanded by the commencement date. So the fact is that the principle of having someone or a group of people protect against coercion is important. The idea, and I'm not just talking about coercion, I'm talking about how people perceive the question of people in authority. But the fact is, royal colleges, social workers have told us they don't believe they will be ready to put those guardrails in place by the commencement date, and we should listen to them. And Mr. Speaker, I will finish on this point. This is an important debate. It has stimulated an important conversation, and it is a conversation that demands our full attention. But I do not believe this bill is ready to go to the other place. And it is interesting that there are both proponents and opponents of this bill who are hoping the Lords will make significant changes to the bill. And that should set off alarm bells, surely. Yeah. And then, Mr. Speaker, the final point. The final point is that ultimately, because this is such a fundamental change, we do need to make sure that we have that enhanced level of scrutiny about the detail of this bill. And I do not believe that, even though, like all of us, we want to avoid suffering and alleviate suffering wherever possible, I do not believe we've had the opportunity to get this bill into a right shape, which is why I will be opposing this third reading, and I encourage others to do likewise.
The two opening speeches took longer. Now we come into the 5-minute, where I hope members will restrict themselves up to 5 minutes, and we're going to have a very good